The court is in session in the case of State of Juristan versus Armagan Randawa. The prosecution, you may proceed.
Good morning, honorable judges. First, before to start, I would like to introduce myself and my team. I am Mohammed Yunus as a mooter of this instant case, and I am presenting the prosecution side. My co-mooter is Ashrafullah, and our team researcher is Madam Rabia. I seek permission from the honorable court. Should I proceed to the arguments, or I should disclose the facts of the case? Thank you, Your Excellency. Your Excellency, the first question of the instant case arises, that is regarding the jurisdiction of the Juristan. That the first question, that the court of Juristan has jurisdiction to try the instant case or not. If we talk about the jurisdiction of the court of Juristan, first it is necessary to elaborate and to explain the word jurisdiction. Jurisdiction is defined as the limit of judicial authority or extent to which a court of law can exercise its authority over suits, cases, appeals, etc. In accordance with the facts, the court of Juristan has a definite jurisdiction over this case because the offense is committed within the territorial jurisdiction. The sea, Juristan has a sea area which is extendable to 360 nautical miles, which is based on the structure of the continental shelf of the state. So the crime is committed at 250 nautical miles from the port of Zawadar. Hence, it means that it falls in the ambit of the jurisdiction of Juristan. Your Excellency, the United Nations Convention Laws on the Sea is an international treaty that governs the use and protection of the world's oceans and their resources. Comprehensive framework for maritime issues, including the establishment of the jurisdictional zones. It does not directly address the criminal jurisdiction or the authority of the domestic courts to hear the criminal cases. Hence, this case falls under the jurisdiction of the local court of Juristan.
As I said, it is 15 months. How, from facts, I think it is not mentioned in anywhere that the vessel is 50 miles away from your ship.
Ma'am, it is mentioned that at 250 nautical miles, this incident happened.
It is the word as we use from that place.
Sorry,
It is doubtful.
yes.
Council.
Yes.
As far as the law of the seas is concerned, there is a certain structure of the law of the seas, the territorial zone of
Yes.
the high seas.
Yes.
Can you please brief us about that particular structure and what nautical miles fall in what?
Yes, sir. Your Honor, to entertain your question of different states. The first zone is the internal water. That is the sea shelf and the seabed, etc. That is the first stage of the sea, which starts in the sea. Then the second stage is the territorial water. That the territorial water extends to 12 miles. Then after these 12 nautical miles, then a third stage comes, which is called as contiguous zone. Honorable judges, that contiguous zone extends to 24 nautical miles. After that contiguous zone, the exclusive economic zone starts, which extends further 200 nautical miles from that contiguous zones. After the final zone is the continental shelf, which extends to 200 nautical miles after exclusive economic zone. That is the seabed, the sea structure.
Mr. Counsel, in the facts it is written that after the shipwreck,
Yes.
ship went somewhere into the sea. However, when we see the structure of the sea, it says that from territorial waters towards the contiguous zone, it is 12 nautical miles. However, when towards the collective structure is from territorial waters towards contiguous zone is 24 nautical miles.
Yes.
However, 200 nautical miles is the exclusive economic zone, as well as the extension of the continental shelf is 360 nautical miles. So how can you say that when it is shipwrecked and went into somewhere into the sea, then how can you say that it is falling within the ambit of the exclusive economic zone, which is 360 nautical miles?
Your Excellency, if we will add the territorial water zone, the internal water zone, and the contiguous zone, in addition of the exclusive economic zone, it becomes almost 236 nautical miles, which is less than 250 nautical miles. Hence, it proves that it is the area of Juristan.
To try to prove that the jurisdiction belongs to this court. But
Yeah.
do you not think that Guyana's three experts are charged with the offense of murder and one was killed?
Yes.
Yes?
Yes.
So it's a big loss for them. It's a
Yeah.
violation of their rights.
Yes.
As well as the ship was registered with the Lara.
Yes.
Do you not think that they also have the jurisdiction in this case?
For your answer, I would like to refer the Honorable Court to the Section 4 of the JPC, Juristan Penal Code, which clearly states that extension of code of extraterritorial offenses. In this section, it is clearly stated that the provisions of this code apply also to any offense committed by. Section 4 further describes that any person on any ship or aircraft registered in Juristan, wherever it may be, In the explanation of the said section, I would like to elaborate that the word offense include every act committed outside Juristan, which if committed in Juristan would be punishable under this code. Hence it proves and it means that it falls in the ambit and in the jurisdiction of Juristan. May I proceed for the next question? Whether the killing of Dilrozain Kazalbakhsh was murder considering the circumstances of this case or not. Your Excellency, the answer of this question is clearly yes. It is crystal clear that it was a planned murder. I would like to draw your kind attention towards a few points that the murder of Dilrozain and all the crew members, they suggested, then they draw a lot, then without the consent of Dilrozain, when he refused to die, they instantly put a penknife on his jugular vein. And furthermore, this statement by the Dilrozain Kazalbakhsh is the proof that he was eager to live alive, that my GF Masho Pali will marry me. This statement means that he wants to live alive instead of dying. So, it was a completely planned murder, and it is clear from the facts that in the extreme circumstances of the survival stranded in the high sea without food or water for an extended period, they resorted to drink each other's blood to sustain themselves. Initially, Dilrozain Kazalbakhsh voluntarily offered himself as a sacrifice, but later withdrew his consent. It proves that he was not ready to die and to sacrifice himself, but he was killed and murdered by Mr. Armagan Randawa in assistance of his crew members. Sir, Your Excellency, do you have any question regarding this question? May I proceed for the next question? Your Excellency, the third question is whether only Armagan Randawa is liable for killing of Dilrozain Kazalbakhsh or not. My answer to this instant charge is that not only Armaghan Randhawa is liable, all his crew members are also liable for the murder of Dilrozain Qazalbash. Why? To answer this question is that all the crew members have common intention to save themselves. They were hungry and thirsty. They were in search of food, and instead of choosing other alternative and other remedy, they choose to kill one of his friends. Furthermore, as per the facts of the case, all members of the crew were planning to kill Qazalbash. Moreover, after his denial, the crew eventually drew lots which indicated Dilrozain's Qazalbakh's name. It proves that once they were suggesting each other, secondly, they were drawing a lot, third, they were, when his consent was not taken from him, he was in coma, the victim, he was killed without his consent. So all the crew members were involved in this murder. Sir, do you have any question regarding this case? May I proceed for the next question? Before to proceed to the next question, I would like to present a case law before this honorable. An exit scene. And in the said judgment that is ordered by Justice Syed Mazhar Ali Akbar Naqvi, the petitioners along with two co-accused were tried to a case registered by FIR number 196 dated 29/7/2009 under sections 302 and 324. Honorable judges, I would like to draw your kind attention regarding 302, that is the plain murder, and 324, that is the intentional murder, the same intention which they did. Then the first point which has been highlighted, that is Muhammad Iqbal and Maqsood Ahmad under section 302 JPC, sentenced to death along with compensation of 30 lakhs rupees payable to legal heirs of Haji Muhammad Aslam and Altaf Hussain, deceased, recoverable as arrears of land revenue in default whereof. It concludes and it proves that for intentional murder they were sentenced, and they have a common intention also among themselves.
What about law of necessity? They are in that circumstance. If a person is being called by the circumstance that
Honorable Court, Dear Excellency, the law of necessity applies where you have not an alternative option, where you doesn't find an other remedy to survive. But here you have other remedies, here you have other solutions to save your lives. So here the application of the law of necessity is limited, because instead of killing your crew member, you can do fishing, you can do an alternative use like Captain Gill used and catch a turtle, and he ate that food and saved her life. So the other crew members and Mr. Armaghan Randhawa could also do the same thing to save his life instead of killing his crew member. So here the law of necessity is limited, very limited. May I proceed for the next one? I would like to call my co-counsel to proceed the case.
Good morning, Your Excellencies. May I proceed further? Question number 4 and 5. So, as my colleague Yunus, co-members Yunus Motor, Yunus Khan, and like researcher Rabia, Miss Rabia presented, The fourth question, whether the cannibalism is allowed or not. The first thing and the foremost thing is that as per the section of the GPC section 297, though the cannibalism is not clearly mentioned, but the dignity and the burial like disposes is mentioned. And there is also law, like a proposal of law in the National Assembly of Juris to be passed and like amendment in this section. So cannibalism is clearly mentioned in this regard. Like cannibalism, we further like means that consuming of flesh or body parts of humans, even under the theory of necessity, which my co-motor mentioned that theory of necessity is limited. Then seeking assistance to disaster signal, it typically regards violation of human dignity. Again, from the Constitution, Article 12, we can that Constitution protects the human dignity. So it's also the violation of human dignity in the area of the cannibalism. So cannibalism have a vast history, like in West and Central Africa, Malaysia, especially Fiji, New Guinea, Australia, and as well as New Zealand, some Iceland Peninsula, among tribes, some Martha, and various states in South America is to be like they have restrained cannibalism. So they did cannibalism and they. So in this regard, I will further move toward the question number 5. If any question in question number 4, you can ask.
Is cannibalism is punishable in Judaism?
What?
Cannibalism is punishable in Judaism?
No, cannibalism is not punishable under the any laws, even penal law of Juristan. Though in 2014, an amendment in the section 297 was.
It's not part of our CPC. So, what remedy this court can give you in that case?
So, the remedy is basically I mentioned that human dignity is violated as Constitution, like Article 12 of the Constitution is like violated, as well as the case regarding the Ali and brothers did cannibalism in like 2011 and punished by for 2 years under the Section 297 of GPC.
Yes, Mr. Counsel. As far as the section 297 is concerned, it says the indignity of the corpses. But here in this case, it was not a corpse, it was a living person who was killed. So what do you have to say about that?
So basically, somehow it's violate like attract this section. Furthermore, I would like to move toward the question number 5, whether or not the principle of common intentions apply to Erazagin and others. Definitely, this question answer is yes, and is open and shut case in regarding the section 34 of GPC, which states the principle of common intentions clearly stated that act done by several persons in furtherance of common intention, when a criminal act is done by several persons in furtherance of common intention of all such person is liable for that act in same manner and it was done by him. Case law is presented before you. So the case laws, we will rely upon this case law that the case law of in the court of Sindh court, like and a bail application was moved. So they denied the bail application because they were involved, the accused were involved in common intention and they were charged about common intention. Furthermore, the bail application rejected on this ground that the SMR 1654, 1996, Mohammed Sadiq and other versus state rejected on this ground, while R 2497, 2006, Senero versus state further that, while YLR 181, Gulab Deri versus state, in this ground this was rejected. So, and another important, yes.
You are arguing in the case of prime minister. This is not the bail estate.
Yes, this was the order of the Honorable Sindh High Court, and they rejected on two SMRs, on the basis of two SMR and two YLRs.
On bail stage, we will not discuss all the case. We see just the tentative points of that case.
So further that,
Bail authorities can be followed in the final stage.
like you said, that there is nothing is mentioned here in the bail application.
My question is whether the bail application.
May I proceed for one?
Yes,
to-
yes,
Yes.
but can answer my question. Bail stage is where we will not go through the evidence. We just take a tentative assessment,
Tentative assessment.
not go through the all. But here we are deciding the case on its final stage. Whether we can present the authorities which are related to 497 into 302.
Your Excellencies, as you mentioned, this is the initial stage of the case, and the bail is also granted in initial stage. So, as well as from granting any bails, because they may be accused from 302 of JPC, and then they would be like rejected from the Sindh High Court on this ground. The bail is basically like rejected on these SMRs and OLRs. So basically, in the initial stage, I presented this order of the Honorable Sindh High Court, and I would like to
Counsel, your time is up.
I would like to prayer clause mention. Thank you. So the prayer from this honorable court is that, in the light of the above arguments, it is further prayed this honorable court may kindly to please to punish the said offender among the co-accused with the heavy punishment in the interest of justice, fairly and equity. And they are inconsiderable dead pets, so they shall be dealt with according to law as well as fairness of law, as Juristan court has jurisdiction over that. Thank you. Any question?
The defense counsel, you may proceed.
Good afternoon, Your Honor. My name is Juris, acting on behalf of defense, along with my co-mooter Shagufta Zohar and the legal researcher Anas Khan. Your Honor, I will be assisting the court with the first 4 issues, and the next issue will be addressed by my co-mooter Shagufta Zohar. May I proceed, Your Honor? Your Honor, the defense counsel not only denies the allegations of the prosecution, but also contests that the Juristan is not competent to trial this matter. To argue that Juristan is not competent, we can follow the following points. Number 1 point is territorial jurisdiction. Your Excellency, Juristan's jurisdiction is primarily limited to its territory and territorial waters. In this case, the incident occurred approximately 340 nautical miles from the coast of Zavada, which is within the high seas. Beyond Juristan's territorial waters, the high seas are considered international waters, not any under the jurisdiction of any specific state. So therefore, Juristan may not have the jurisdiction to try this matter. The next point is the nationality of the accused and victim. Your Honor, as per the facts, the Armaghan Randawa and the Ruzan Kazarbash, the accused and victim, were the nationals of Naina, not Juristan. They both are not the citizens of Juristan. The country may not have jurisdiction over crimes involving non-citizens committed outside its territory. Your Excellency, as mentioned in the facts, their contract was for fixed period of the year, and it was set to automatically terminate upon the expired. As a result, they were no longer officially representatives of Juristan. When this unfortunate event took place, this raises question about whether Juristan can exercise jurisdiction over individuals who were no longer under their services and acting on its behalf. If you do not have any question, may I proceed towards second issue?
You may.
Your Honor, the second issue is whether it was murder considering the circumstances. Your Honor, they were compelled to commit the act of killing Diloz and Qazalbash due to the dire circumstances. They found themselves in while stranded at sea. Your Honor, the crew was faced with an immediate and life-threatening situation. They were stranded at sea without any means of obtaining food or water, and no rescue was in sight, which with each passing day, the danger of their lives increased. Your Excellency, the next point is lack of alternative. Your Excellency, the crew had exhausted all other reasonable option for survival. They had no access to fresh water and their food supplies had run out. The nearest land was too far away to reach on their navigation system to call for help. Your Honor, the act of killing Diloz and Qazalbash was a proportionate response to the dire circumstances they faced. By sacrificing one life, they sought to preserve the lives of the remaining crew members. Your Excellency, for the say, if the crew genuinely believed that killing Dilozen was necessary to survive, they were under extreme physical and emotional distress, which affected their decision-making process, and they had no intent to commit murder. Your Honor, the crew did not act with malicious intent. Their primary goal was to survive, not to harm Diloz and Qazalbash beyond what was necessary for their own survival.
Council, it means we are supporting the circumstances. If we have an extreme drought, as part of some countries we have, that means we allow the people to eat themselves in that situation.
No, here, Your Honor,
As you know, there is no share in our areas, in that most of the areas they have drought areas. So we allow them to eat themselves.
Your Honor, the circumstances is too much different. They have no another other alternatives. No another, as per the facts, there was no another alternative to survive. Circumstances is something different. They have alternatives. They can earn. They can go for another alternative, but they had no alternatives. They were stranded at sea.
Yes, Mr. Counsel, but as the fact states that that particular person was an expert in geological and marine sciences. So, don't you think that he could have found another way, any other fishing or anything which could have saved this person's life?
Yeah, of course. But before, if it was, it would not be shock attack. The shock attack and the all navigation and connection system was destroyed. So he was not having another option.
What about that, Mr.
Your Honor, if you do not have any question, may I proceed toward third
My
issue?
question is, as you said, they have no option. In para 5, we have that Mr. Arozal is the captain of the ship that's called the turtle. It means they have options. They have some means to catch fishes.
The turtle was there was absolutely, if there was an alternative, why they would go for cannibalism? Why? It means there was no another turtle or another alternative. Therefore, they go for cannibalism.
That means they had malign intention to kill that person or not?
No, because as for go for history, they have no criminal history. Their history is absolutely clean from any criminal issues. We have no another alternative apart for going cannibalism.
How does a criminal history matters if you want to commit an offense?
It was for the sake of argument. It was just example. For
Just example.
yeah, for the sake of arguments. May I proceed towards third question?
Yes, you-
Whether
Any authorities or anything about these 2 points?
authorities.
Any
Yeah,
differences?
yes, we have here the theory of Iceland. It's regards to first issue. Your Honor, theory of floating Iceland suggests that when a ship carries the flag of any state is on the high seas, it carries the same rules and authorities as if it is on its own land. This means that the ship is on the middle of ocean. May I proceed towards the third question?
Yes, please.
The third question is about whether only Armagan Randhawa is liable for the murder of Diluz and Qazarbash or other crews. Your Honor, neither Armagan Randhawa or nor any other crew members were liable for the killing of Diluz and Qazarbash. It was the principle of collective responsibility and the unique circumstances that led to the tragic event. The first point is shared circumstances. Your Excellency, not only one member was in such disparate circumstances. All crew members were facing the same life-threatening circumstances, and their actions were a collective response to the dire circumstances they were in. The decision to consider cannibalism was made collectively, and each member was equally affected by the extreme condition of being stranded at sea without food and water. The next point is lack of criminal intent. Your Honor, none of the crew members had criminal intent or premeditation to commit murder. Their primary objective was to stay alive, and they did what they believed was necessary to ensure their survival, even though it led to the tragic outcome. Any question, Your Honor? May I proceed towards number 4? Number 4, whether cannibalism is lawful under the theory of necessity.
One of your contentions says that in your current submission that there was no clear criminal history. I earlier asked that what is the significance of not having a criminal history, but you're again doing something that amounts
Yeah,
to a criminal liability.
Here is mentioned in memorial, but I didn't mention it now. I just gave the example. It is also just for the sake of arguments.
For the sake of argument,
Yeah.
you are
We
standing
can-
in a court of law and saying for the sake of argument.
We
without
can-
any legal differences.
We
It
can
is
go.
justified and admissible.
As I gave just they said they were planning to kill, means they had something between Diluz and Qazarbash and Armagan Randhawa. That is why Armagan Randhawa killed him. I said no. They had no another alternative option. That is why, and also he has no any criminal history. That's why I provide the criminal history to defend him.
How would you basically define this criminal intention?
Criminal intention, it's when you have mens rea and actus rea. Okay, it's called criminal intention.
Criminal intention is a guilty state of mind, right? How would you prove it?
Yes, they had no any guilty state of mind. They were
Guilty
compelled.
state of mind in drawing notes about notes for the Ibrahim Hazarbash, whether he should be killed or not, isn't it sufficient evidence?
No, they were compelled to make this kind of strict decisions by the circumstances. They were compelled. They had no another option. That is why they go for the killing of the Luzan Kalba, because he was too much weak and partially dead.
Now, so we have taken your point. Contractual obligation in your memorial.
Yes.
It says that, however, the contract was related to exploration and research of marine resources in the high seas. Do you just think that the contractual obligations apply on the high seas only?
One minute, Your Honor. Yes, page number 4, contract obligations. May I read? The activities of the expert team, including Armagan Randava and the Rajan Kazalbash, were based on a contract with the federal government of Juristan. However, the contract was related to exploration and research of marine resources in the high seas beyond Juristan's jurisdiction. The contract did not explicitly grant Juristan the authority to adjudicate.
Okay.
Yeah.
My question is that, how can you say that the contractual obligation was applicable on the high seas? Because high seas are the international waters, and all the states have equal control on that. So how can you say that they were contractually obliging in that particular international water territory?
Then, Your Honor, we can go for the ship. The ship was registered in Zizo Company, and Zizo Company was registered Dilaram. So here, Dilaram is categorically having jurisdiction.
Can you please enlighten the court that when the general exemptions and the clause of self-defense are applicable or functional?
Call self-defense.
You have mentioned
Yeah. I have made several mistakes in memorial. So I have made several mistakes in memorial. Here we do not go for here for personal defense. May I move towards fourth question?
Yes, you will.
Whether cannibalism is lawful? Your Honor, here we can go for theory of necessity. Arguments here nearly in Juristan, their election is extendable just because of what? Just because of necessity. It means it is also the violation of constitution. So if any state can violate the constitution on basis of necessity, why not the others? They also violate the constitution on the basis of necessity. It's here, so it means we can somehow, in certain this kind of circumstances, we can violate the constitution on the basis of necessity. May I call my co-mooter for the last issue?
It's me, Shagufta Zahur, sir. Voice is coming.
Can you speak a little bit loudly?
It's me, Shagufta Zahur, on the behalf of defense. The last issue is whether common intention applies to Heroza Gill. Lack of the awareness, Your Honor. Heroza Gill questions who caught this fish indicate her lack of awareness of the circumstances surrounding the killing of the Lausanne and the consequent consumption of his flesh. The question suggests that she was aware of what's happened. Your Honor, Arosa Gill did not actively participate in the decision-making process or the act of killing Dilosan Ghazalbash. She was not directly involved in the decisions of or actions that lead to the tragic event. Your Honor, Arosa Gill had no prior knowledge of the crew plan to resort to cannibalism. She only became aware of the situations when it had already unfolded and she had not opportunity to influence or prevent the events. Limited communication. Your Excellencies, the court communication were destroyed by the shark attack, which hampered the crew ability to communicate and share intentions clearly. Arozagil was not fully aware of these discussions and discuss made by the others. Lack of consent, Your Honor. Arozagil did not provide her consent to participate in any illegal and unethical activities, including cannibalism. Arozagil was not experiencing extreme emotional distress and fear due to the harrowing circumstances they were facing. This distress may have clouded her judgment and made her incapable of forming any common intention with the others.
Ms. Counsel, just clarify this one thing to me, and that is that you said that in the fact it is written that who caught this fish.
Yes,
So,
sir.
for a sane person and a sane mind, how can we accept this fact that she was unable to differentiate between a cannibalistic meat of a human being as well as a fish? Because a normal person can easily differentiate between a fish and a meat.
सर उसने कहा था कि ये डिलीशियस फिश किसने पकड़ा है, सो उसको पता नहीं चला था कि ये ह्यूमन का फ्लैश है या फिश का.
You also mentioned that she did not give her consent, right?
Yes, sir.
उसने अपना consent ले लिया, लेकिन उसने objection भी तो नहीं किया.
उसने ऑब्जेक्शन नहीं किया था बट उसे कोई इंफॉर्मेशन नहीं थी इंक्लूडिंग दिस
उसने discussion में part लिया.
टिल लॉर्ड्स उसने पार्ट से वो किया था, डिस्कशन में पार्ट लिया था बट आफ्टर दिस उसका कोई कंसर्न नहीं था.
Counsel, your time is up.
She had the knowledge कि ये कुछ इस तरह का incident या possible circumstances के होने वाला है. Still she did not object on that.
आफ्टर दैट उसे कोई इंफॉर्मेशन और नॉलेज नहीं थी कि उनका इंटेंशन क्या है उसके क्रू मेंबर्स का.
She was living in the same ship.
पर ऑन द फैक्ट्स यही बताया गया है कि आफ्टर मतलब उन्होंने जब फेरोजा बिल ने कहा था कि उसका एक बॉडी पार्ट काटेंगे, आफ्टर दैट उसका कोई कॉन्सेंट नहीं था फेरोजा गिल का.
Clearly understood that she was on the same ship. She did not raise any objection. Yes.
Yes.
She took part in the discussion of killing the Roseanne and cannibalistic meat.
मैम उसने डिफ्रेंशिएट नहीं किया था, तभी तो उसने कहा कि ये डिलीशियस मीट किसका है. अगर वो कर पाती तो उसको पता चल जाता कि ये ह्यूमन बीइंग का है. So the prayer clause is the defense prayers to the honorable court to refer.
Counsel, your time is up.
Sir, I need just 2 minutes for my prayer.
Yes, one minute.
The defense prayer to the honorable court to refer the matter before the competent firm to acquit the accused, since cannibalism is not barred by any substantive law of Juristan Penal Code. We request the court to set aside Section 302 since the victim was already dead. Thank you.
Prosecution, you may proceed for your time.
Your Excellency, may I proceed? Thank you. While denying the jurisdiction of Juristan, the defense counsel didn't mention any national law, international law, or any other source of law for his denial. The second thing is, for a non-national accused, they shouldn't be tried for a criminal act if they are not a national of a state. The third thing is that Captain Erozagil stated that who caught this fish. As Captain Erozagil was a expert marine geologist and oceanologist, she didn't differentiate the meat of a fish, even though she was habitual of taking fish in sea. While she didn't differentiate the difference between the stiffness and the blood of the human flesh and the meat of the fish. The third thing is that the defense counsel alleged that all the navigation system of the ship was destroyed, as it was mentioned in paragraph 5 that a few navigational system was destroyed, rest of the they were remained. Thank you.
Answer your time is up.
You answer me a question. This vessel, this ship is belong to GB company, right?
Yes, sir.
Then why this bench shouldn't transfer this case to Baba, the Dilara?
Sorry, I didn't get you, ma'am.
As we know, this ship does not belong to Sweden,
Yes.
right?
Yes.
The jurisdiction of this case can't be on the state of Dilara.
Your Excellency, to answer your question, I will take a refer to section 4 of JPC, in which it is stated that even it is without the territory of Juristan, they can trial for such offense.
Until and unless they are your employee, but they are not. As the
They were employed by Juristan and they started their journey from the port of Zawadar.
contract has been expired.
They started their journey from the port of Zawadar, and the port of Zawadar is a part of Juristan. Hence it applies on them. Thank you, Your Excellency.
The defense counsel, you may proceed for certificate. You have only 1 minute.
Your Honor, the prosecution counsel mislead the court by giving the wrong information, the wrong location of the offense, where the offense has been committed. They have no idea, or they didn't give the specific location. Secondly, as he said, if any non-citizen commit crime or offense, whether he or she may not be tried, yes, they must be tried and they should be tried, but in the competent court. And Juristan is not competent. And as my prosecution said, that they had alternatives, but here in the facts, they had no other optional and alternatives, therefore they go for cannibalism. Thank you so much.
Please all rise. The court has adjourned.